Hey guys, how's everybody doing? Probably no surprise, but Brian Steele and Keith Adams have very swiftly filed a response to the state's motion to revoke Young Thug's probation. It's short, we're going to take a look at it. Joseph Papp had shared it. I believe Thugger Daily also, I assume Thugger Daily has also shared it. And it's like 4 pages. So if you missed the state's motion, we looked at that yesterday. That was a time that's linked in the description if you want to go back and check that out. People have had a lot of thoughts. And let's see what Steele and Adams say here. So filed today, this morning. Make this bigger. Mr. Williams' response to state's motion to revoke probation comes now. Jeffrey Williams, and his name is spelled correctly this time, by and through undersigned counsel, and hereby files this response to state's motion to revoke probation in the above referenced case. In support of this response, Mr. Williams shows as follows. On or about April 2nd, 2025 at 7:48 p.m. Why are we calling this out? The state filed a motion to revoke Mr. Williams' probation. They're underscoring the time. The prosecution must place in writing, pursuant to the Due Process Clause of the United States Constitution. So, federal procedure, federal requirement, as well as the state constitution, the specific act or acts that Mr. Williams supposedly committed to violate his probationary sentence. As shown below, the prosecution's motion to revoke Mr. Williams' probation fails, on its face, to allege any conduct by Mr. Williams that would rise to a violation of the probationary sentence. So there you go. Quick summary of their response here. They didn't articulate what the violation is. Taken in light most favorable to the prosecution's allegations. So we're looking at this in the best light for the state. We're giving them the benefit of the doubt in this motion to revoke probation. This honorable court could not find, as a matter of law, or as a matter of fact and or law, that Mr. Williams violated any term of his sentence. And here they cite Miller v. State. The Honorable Court of Appeals of Georgia reversed the trial court's determination that Mr. Miller violated his probation since there was no, and this is going to continue since this is pictures, we got to switch windows. And this is a 2025 decision that they're citing here. So there was no evidence to support these findings. The state's motion to revoke probation must allege conduct, which, if proven by a preponderance of the evidence, shows that Mr. Williams violated a term of his probation in the specific manner charged in the motion to revoke probation. So we've got 2 issues here, right? The term, there has to be a term of which can be violated in his deal. So the terms of his probation, the term has to be there. And then it's also got to be articulated in this motion to revoke probation. We need those 2 things. And they cite here Moten v. State. As discussed below, taken in the light most favorable to the prosecution's assertions, Mr. Williams did not violate any term of probation, and thus the state's motion to revoke probation must be dismissed at this time with prejudice. So they can't raise this issue again. And I'm sure, it must be dismissed, and it's not unusual to suggest with prejudice, but I feel like you have to emphasize when you're dealing with Fulton County, with prejudice, don't just give them the red carpet to keep trying to do this thing over and over and over again. The material allegations in the state's motion to revoke probation are as follows. So, 1, at a preliminary hearing in an unrelated case, the magistrate court ordered that no witness be shown on television while testifying, and a, quote, known blogger deliberately violated, end quote, that court's order by posting on social media a photograph of investigator Viverito. This allegation has nothing to do with Mr. Williams. First, even if the, quote, known blogger did not violate the magistrate court's order as asserted in the state's motion to revoke Mr. Williams' probation, because there was no image shown of investigator Viverito while testifying in this unrelated proceeding. This allegation cannot support the revocation of Mr. Williams' probation. So, great succinct argument here, but there's layers to that, right? Like, there's a separate proceeding, and somehow Jeffrey Williams reposting a picture that has Viverito in it, an old picture. It's not any footage from a trial or hearing, or specifically this hearing that took place in the OMF case over the past week. It's a different picture entirely. He reposts that with the caption of biggest liar in the DA office. How the state doesn't articulate how that's a violation of a term of Jeffrey Williams' probation. And in fact, they don't even identify the quote known blogger. So they're not even being specific in their accusation of what happened and how it relates to Mr. Williams. 2, Mr. Williams, quote, ... amplified this blogger's act by reposting the image with the caption, Marissa Viverito. Now pay attention here. This is they're quoting the state's motion here, where the state said, Marissa Viverito is the biggest liar in the DA's office. They're saying those words, Marissa Viverito is the biggest liar in the DA's office, the state in their motion was saying that was the caption of the image repost. So what does Steele and Adams argue? First, there is no suggestion that Mr. Williams knew of the magistrate court's order not to show investigator Viverito on television while testifying. So this footnote's important. A person cannot violate an order unless they have knowledge of the order itself. Second, the allegation asserts that Mr. Williams reposted an image and wrote a caption. This allegation does not violate the magistrate court's order or Mr. Williams' conditions of probation. We've got a footnote here that says, additionally, if a hearing is needed, if we even need to have a hearing on this, there will be no competent evidence that Mr. Williams was the person to repost any image or write any caption as alleged in the state's motion to revoke probation. Because remember, they had a section in their motion that said direct threats. And in their exhibits, their exhibit A contained multiple posts from different people. And one person screenshotted, it seems like they reshared Young Thug, but they added their own caption talking about how Viverito used to live in the same community where the poster, who's not Jeffrey Williams, had a bunch of Airbnbs, and she did something to mess that up. Somehow the state's including that as an exhibit that somehow Jeffrey Williams is responsible for. So this is a great point here, like, how do these exhibits tie back to Jeffrey Williams? They're claiming he's responsible for them. 3, and also important language here, actually. So this last sentence here, third, there's no violation of Mr. Williams' probation by reposting an image on social media and opining that investigator Viverito is untruthful. So it's an opinion. He has the right to say that. That's not a violation. To have an opinion, there's nothing in his terms of his probation that restrict him from having an opinion. 3, the prosecution asserts that Mr. Williams' repost went, quote, viral, and unknown persons commented on same, which included supposed threats to investigator Viverito, her family, as well as the district attorney. We're not even getting the name here, we're just saying the district attorney. This is reminiscent of lowercase lawyer Love and Hilton. Mr. Williams, undersigned counsel, and all moral persons do not condone threatening another without justification. However, these comments on social media by unknown persons cannot be attributed to Mr. Williams in order to support a violation of his probationary sentence. 4, the state's motion to revoke Mr. Williams' probation then lists, quote, direct threats in the attached exhibits. Yes, this was such a pet peeve. They gave a whole section header describing direct threats. That was the section header. And then underneath, there's no direct threats. Again, this allegation did not allege any act attributed to Mr. Williams to support a violation of the probationary sentence. 5, the prosecution speciously alleges that Mr. Williams is conducting a, quote, calculated campaign of intimidation, harassment, and misinformation designed to undermine the legal process, and other baseless assertions. These conclusions do not support a motion to revoke Mr. Williams' probationary sentence. And 6, the remainder of the state's motion to revoke probation is argument without any substance to allege an illegal or unlawful act conducted by Mr. Williams. So, real short and sweet. And again, you need the two things here. So the things that the state's claiming they're not even supporting, and they're also not making a showing or pointing out what exactly the violation is. They haven't pointed out how these things are a violation of this probation agreement. So they go on to say a revocation of Mr. Williams' probation involves the loss of liberty, which is a serious deprivation, and they're citing here Great House v. State. Therefore, Mr. Williams is entitled to due process of law. We've also got Meadows v. Settles. This honorable court may not revoke any part of Mr. Williams' probation unless Mr. Williams admits the violations as alleged in the state's April 2nd, 2025 motion to revoke probation, or unless the evidence produced at the revocation hearing establishes by a preponderance of the evidence the violations alleged. In the case at bar, in the light most favorable to the prosecution's motion to revoke probation, Mr. Williams can admit to all the allegations alleged and still not have violated any term of his probationary sentence. This is a very lawyerly way of saying the state's not using law. They're just making argument. Even if Jeffrey Williams wants to take, if I directly caused all these things you attached in your exhibits, it's my fault, still it wouldn't, it's not a violation of the terms. Thus, the state's motion to revoke probation is deficient. Therefore, Mr. Williams asks this honorable court to deny the state's motion to revoke probation without a hearing. If a hearing is needed, Mr. Williams will be prepared. They're going to say this last line was a threat. They're going to say it's a threat. He's going to be prepared. So, wherefore, Mr. Williams respectfully requests this honorable court to order the motion to revoke probation be denied. Then you've got Brian Steele and Keith Adams here. So there you go, guys. We'll get some comments, and then we're going to look at a clip of Fani Willis. As soon as we ended the stream yesterday, I switched over to Twitter, and there was a very fun clip of Fani speaking to the press. So we're going to look at that. Here Comes Drama says, good grief. That's a great summary. Ron Barnes says, Love knew they had no case, so they backed out. Now, yesterday's motion to revoke was written by Fani Willis and also signed on to by Hilton and Abate. So, yeah. I'm Her says this is the hybrid gang that Viverito speaks of. And someone, Mel, I'm not a lawyer, has an Exhibit F book because she was in one of the motions the state filed to restrict extrajudicial statements when Doug was doing interviews. I think Keith Adams is doing interviews. And that's that document where they cite I'm not a lawyer but as Exhibit F. So she has a notebook where she has a bunch of quotes relating to the YSL trial. And someone's like, I love that that's the last time you gonna call me a hoe. And that was Viverito approaching Kayla Bumpus in the hallway. And she said that to Kayla Bumpus. And Doug Weinstein wanted to bring it to the court's attention. And Whitaker was like, I'm not really sure I find that threatening. And Doug Weinstein replied to the effect of, I've had clients charged for far less than a statement like, that's the last time you're going to call me a hoe. So even in this mix of, this is all centered around Viverito testifying in a hearing and people talking about Viverito on social media. And when you think about it, we had an issue in the YSL trial where Viverito, I don't see how by the state's reach here, their same logic, if you applied it to Viverito, that Viverito wasn't in that hallway threatening somebody that was a witness in the YSL case. But here we are. I guess we only look in one direction. So yeah, I'm Her. This is the hybrid gang we speak of. Jamie Daniels, good to see you. This is so, we have the googly eye face. Good to see YSL Whitaker in the chat here, Cash Money Cass. I was on Facebook today and someone had YSL in their username and I'm like, every time I see it, I just laugh. Let's see. Shout out to Asia Mullen. Thanks for being a member. Thanks for coming to hang out. We've got, Joe says we're back finally. Yeah, not really on fun circumstances, ridiculous circumstances. Funny to me, but not fun. The Blatantly Blatant Network, good to see you, says, I'm gonna be honest, Thug should never have said anything about any of them people till he was off probation. And for what it's worth, I do not think he should be restricted from saying what he said. But at the same time, sometimes when people will do anything to put a target on your back, even though it shouldn't be your burden to prevent someone overreaching, sometimes having the foresight could prevent a lot of hot mess. And personally, I am hoping that Judge Whitaker, if there's a hearing, I'd probably enjoy what happens at the hearing and seeing how things are argued further. But at the same time, I personally agree with Brian Steele and Keith Adams, their request that this is deficient. The state's request is deficient on its face, and that it should be denied without even the need for a hearing. So I want that as the ultimate outcome. But again, sometimes you can avoid things by going out of your way or not doing something that you should be allowed to do, but someone's going to raise an irrational issue with it, which sucks. That really sucks. Let's see. Yep. Brian B., that's where I stand. You know, free speech, First Amendment, I disagree. And again, the extra layer here is they're complaining about somebody's speech, but they're not pointing out how it's a violation of the terms, but they're moving to revoke somebody's probation. And you've got to meet certain criteria to successfully argue for a motion to revoke someone's probation. So I agree it's deficient. Fit Lawyer ATL in the chat, good morning. She said she woke up and saw this mess. Oh my goodness. Just a whole time. I have the clip pulled up. Where did I put it? Let's look at, so yesterday we read, an article where Brian Steele had first said, Jeffrey Williams didn't do anything to violate his probation. Right after we ended the stream. I see this clip from Fani Willis. I tried to put it in the chat before the chat shut down, but I think you guys were already filing out. So let's look at this clip and see what you guys think.
District Attorney Fani Willis.
What our motion is concerned about is that we certainly believe that his post was to threaten law enforcement, which is all part of gang activity.
Jeffrey Williams' attorney Brian Steele told me by phone it is never appropriate to be engaged in any type of witness intimidation. It is never appropriate to threaten to murder another person. The prosecution's motion to revoke Jeffrey's probation should not be well received and should be swiftly rejected. It is irresponsible to file a motion of this sort when Jeffrey has done absolutely nothing, Steele said, to violate any condition of probation or threaten a witness.
We know that it is clear to Mr. Williams that the intent of the district attorney is to stop gang activity in Fulton County, Georgia. We believe the judge's order is clear, and that this is an intentional violation.
District Attorney Fani Willis.
What our motion is concerned about is that...
All right, so Manders is saying it can't hear it, so we'll replay it and I'll recite it.
We certainly believe
that
his post was to threaten
law enforcement,
which is all part of gang activity.
So, I mean, there's really not much to unpack there. To me, it's a complete reach. He posts a picture that has Viverito in it. It's not a picture from the hearing. And as Steele argued, there's nothing to indicate that he's aware of some court order, and even so, this picture wouldn't violate that court order. But he said, biggest liar in the DA office. Is that a threat to law enforcement, consistent with gang activity? And it's like, when people say things like that for the news, they show up to do a sit down with, what is this, WSB-TV, Channel 2? You're just saying something and hoping that you're the only thing that somebody consumes. They don't actually go and look at the context of the post itself. They don't see the rebuttal arguments. They don't actually look at the whole filing to decide for themselves. You go and sit down for this and you try to put your spin out there, and it doesn't match. It doesn't match what's actually going on. So I don't know how calling someone a liar is threatening, and I also don't understand how in the context is, if the OMF trial is going on, is Young Thug supposed to be like leading and supporting OMF? What benefit would it be if he was threatening Viverito in a separate trial? I just don't get how that would benefit YSL and the gang activity that Jeffrey Williams is supposedly in charge of. It just seems like backwards logic. So I don't know. We also have, and I don't know if Happily Angry Lawyer's in the chat, but he did post this update this morning Judge Whitaker, this is in relation to Duke Martinez Arnold, the civil forfeiture case, because remember, a bunch of property of not just Jeffrey Williams, but also Martinez Arnold was seized during the raid on Jeffrey Williams' home. And I don't know, was it like March? Back in March, a few weeks ago, state submitted a motion seeking for default judgment, and Judge Whitaker granted it. And Twitter's got to talking. They're like, wait, there seems to be an issue here. It seems like there was a stay in place and that stay hasn't actually been lifted. So I don't know exactly what Ashley Merchant argued to the court, but today, Judge Whitaker says, you know what? The above styled matter, having come before this court upon review, and noting that the order for stay previously entered has not formally been lifted, but is being so lifted via separate order filed contemporaneously here within. So the stay is being lifted today, the same day that this is, or I guess the 1st of April, is being filed. So they strike this order that she filed on March 17th, granting a default judgment to the state, which would have given them, Duke's property. So now they're going to have motions. She wants motions from both parties and anybody that might have any interest in the property being held. By April 21st, we want any response to the motions. And on May 5th, the court will conduct a hearing on any pending motions and or claims to the property at issue. So state almost had a win. And then Whitaker said, you know what? Nope, that's actually not right. That's not, we can't just give you the default judgment there. So very good ruling here, I think. And let me pull up the link if you want to do a deep dive on what those actual issues were with that request for default judgment. Happily Angry Lawyer did a video breakdown on it, and it was really good. So let me get the direct link to that video. Especially since he never links to his own stuff. So he'll just say he talked about something and then won't link to it. All right, so the link to Happily Angry Lawyer's video in there is in the chat for you guys. That's kind of our recap today. A separate thing I was thinking about is I saw some people talking about Def Greg. He's facing criminal charges. I think that's not Mounk Tounk, but a different brother, a younger brother of Jeffrey Williams and Dolly. And he's got a gang charges pending against him. And it's my understanding that Viverito's also the lead detective on that case. So even if there's supposedly an issue with Jeffrey Williams somehow, some way calling someone a liar in a case that they were involved in, we don't actually know that that's the reason he was calling someone a liar 2 days ago in a post. He could be talking in reference and having a grievance with what's being done to Def Greg. So, because in the state's motion to revoke, they asserted that he made that statement to interfere with this case. And when you're filing, I don't know if they meant this case that we mentioned previously, the OMF hearing, or this case, the case number attached to this indictment, which would be the YSL indictment. It wasn't very well written, so that's unclear. But he could have just been making commentary for a multitude of reasons, a wide expanse of experiences where he's come to the conclusion based on his experience and what he knows that Viverito is a liar. And there are plenty, I myself, I'll raise my hand. I came to that conclusion myself based on what I saw in the YSL trial. I think it was reinforced this week by what I saw her testify to in the OMF trial, which Infamous Sylvia is streaming some of that content. There's no court TV or Law and Crime in the courtroom for that. But Viverito was like, I wasn't in Atlanta for Operation Planners. I don't know anything about that. That can't be true if you're a gang expert that came up and at the very least got the backstory on the Operation Planters. If you're supposed to be a gang expert in YSL specifically, how do you not know anything about Operation Planters? Whether you were literally there that day in the office while it was being inked, or learning about it after the fact. Like, it just doesn't make sense. Unless And maybe this is a good explanation. She's conceding that Detective Dennis, Mark Belknap, and Miss Underwood weren't really the best mentors to come up under. But she argued that that's a good reason to qualify her as a gang expert, that mentorship. Brooklyn. So Doug is giving an interview later on Justice Served TV. So shout out to Justice Served TV as well. They do a ton of interviews. And that'll be good to hear. Doug did a short video, I think, on his TikTok. He said his head popped off reading the state's motion to revoke. It does seem like a provocation a little bit, though. But I think that'll be a very, very good interview. I love the Justice Served TV panel. Linda especially is very animated. I'm sure she's going to have some thoughts on the state's audacity here. So that's going to be a good time. Also CMT says, what about Gaither? You know, in the Daubert hearing, she just named those three. She didn't mention Gaither. So I don't know if that was just, you know, when you try to list things off the top of your head, you give 2 or 3 examples and stop there, and it's not meant to exclude somebody, or maybe she intentionally excluded that name. I don't know. Yeah, Mark Wardle says, I told you they did not want the shooters. They wanted the guy singing about it. Thank you, Factual Lie. Factual Lie just dropped the link to the Justice Served TV interview. Also, Just a Chill Girl says, Kat, I have missed you, girl. We are back under ridiculous circumstances, but it's been really nice to be back. Glad you're here hanging out with us. Yeah, Fatima Barrett says, if you ask me, Fani thinks she's above the law. Do you guys want to take a rewind and look at the extrajudicial statement motions that were filed? These were filed back in July of last year. And this was, the state got upset because Doug Weinstein and Keith Adams were doing interviews. They're going on YouTube interviews and, you know, chatting about the case and the request to recuse Judge Glanville and the ex parte. And the state's like, Judge, you need to restrict their statements. But back then, Doug and Steele and Adams both made some very great arguments. And I was revisiting that yesterday and I'm like, these are pretty applicable. Because this motion to revoke Jeffrey Williams' probation sure seems like a request to limit not just his speech, but other people speaking on social media somehow, some way, in association with Jeffrey Williams. Let me pull this up. We can look at some of those quotes. The Doug Weinstein one, the Brian Steele one was the famous lowercase lawyer love document that everybody loves. Let me get the links. Oh, and here's I'm Not a Lawyer But's notebook, by the way. This is what I was talking about earlier. She's got this line down here. This is the last time you're gonna call me a hoe. Good times. If you guys want to check out this notebook, here's the link in the chat. But I swear I shared the motions yesterday. Okay, here they are. So this was Love's motion. Love wrote this motion back in July of last year. She wants to restrict these extrajudicial statements. So we'll start with her 2-page hurt feelings. So she had said, we want to instruct the defense to refrain from making further extrajudicial statements about this case moving forward. And by the way, just generally, when a party is moving to restrict someone from speaking, it should be a specific request. There should be a good reason for it. Because again, you're moving to restrict something that typically is covered by the First Amendment, unless otherwise excluded by, you know, some type of code of conduct. But if you don't delineate, if you're not specific with it, that's a really big ask to just broad stroke deny someone their First Amendment right. So she says here, Georgia Rule of Professional Conduct Rule 3.6. prohibits lawyers participating in litigation from making extrajudicial statements a reasonable person would, quote, believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. And then they cite the same thing in the footnote. A relevant factor in determining prejudice is the nature of the proceeding involved. And they just keep citing the same rule. With criminal jury trials being the, quote, most sensitive to extrajudicial speech, the character, credibility, reputation of a party, which is, we know this is the issue, right? She felt like the other side was doing these interviews to cast personal aspersions on her. And, quote, any opinion as to the guilt or innocence of a defendant are subjects deemed to be more likely to have material prejudicial effect on a criminal proceeding. Defense counsel have made numerous extrajudicial statements explicitly about this case while the jury is sworn and seated during the state's case in chief. Defendant Williams' counsel attorney Brian Steele and Keith Adams, defendant Kendrick's counsel attorney Doug Weinstein, and second page, and defendant Stillwell's counsel attorney Max Shart have all made extrajudicial statements to the media explicitly discussing this case in violation of Rule 3.6. And now here, this is where you would typically expect a quote that highlights something that was said that rises to the level of violating the Rule 3.6. But what do we do here? What did we do with this argument? The extrajudicial statements have included, among other things, interviews and statements to the Associated Press. 4 of those interviews have been 25, 33, 43, and 107 minutes in length. So we're arguing that it's an issue that they talked for a long time, instead of pointing out, underscoring where the violation actually was. What was said that was above and beyond what's allowable. The statements include, among other things, the attorney's views and opinions about the case itself, opposing counsel, and now former judge, the jury, the outcome, and the guilt or innocence of specific defendants. So a very vague categorization here. Pursuant to OCJ 15-13, Section 4, courts have the power to control, in the furtherance of justice, the conduct of its officers and all other persons connected with the judicial proceeding before it, in every matter appertaining thereto. So the state moves this honorable court to instruct the defense to refrain from making extrajudicial statements about this case moving forward. So really the request is they can't speak outside of court. That's the request. That's a huge request. And they didn't show a basis to justify that big ask. So with the responses, you guys will remember the one response from Brian Steele and Keith Adams addressed several motions at once. So that's a really big document, but we're just going to look at a couple quotes from it. And we're going to look at Doug's, because Doug had some big gems in there. And I didn't attach the exhibits, but this is where in the exhibits they like link to these hour-long like YouTube videos. All right, so some highlights. We'll do some highlights from Doug here. So, and this is Doug and Katie Hingerty. Katie Hingerty also helped write this. So shout out to Katie as well. Comes now defendant Diamante Kendrick in the above styled case in opposition to the state's motion to restrict extrajudicial statements, showing the court the following. So we get a Sir Winston Churchill quote, "Everyone is in favor of free speech. Hardly a day passes without it being extolled, but some people's idea of it is that they are free to say what they like, but if anyone says anything back, that is an outrage." We've got another quote here. He's going to quote Fani Willis. So notice right away we are getting a specific quote. So Doug is going to make an argument. He's making an argument of they can say what they want, but nobody can say anything about them. And he gives a specific example with a date and a quote from Fani Willis. "I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it, which you do that for a form of intimidation and to further the gain and to not be held responsible." The Honorable Fani Willis, Fulton County DA, press conference of August 29th, 2022. So these are things that she's specifically saying in her press conference about YSL in the indictment. So this was fine. Doug says, free speech for me, but not for thee. Is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. The state would apparently like the present trial to be conducted in secret. We've already had the ex parte meeting happen. With proceedings happening in hidden chambers outside the prying eyes of the press and the public. The state has repeatedly sought the secreting of... next page. Witnesses' identities. So, certain witnesses don't want to be shown on camera, even in instances when the state has made no showing of risk to the witness. And this is from July of last year. But after this filing, after this time period, there were like 3 to 5 more witnesses that I remember offhand, where the state just suddenly gave notice to the court right before the witness was about to take the stand that day, saying that they wanted the cameras not to show that person. And, the defense counsel, they fought against that both times. And one of the days they specifically said, they didn't even make an argument about this. They're just telling you now, right before they get up on the stand. That's not the way this is supposed to work. So it was already an issue back in July, and it came back up. It became a cliche in the trial from this point forward. After attacking the integrity of respective counsels for defendants and witnesses, repeatedly calling the Honorable Brian Steele a liar. Right, you can call Brian Steele a liar. And there's an extra standard here, right? So you've got a person on social media who's not an attorney calling somebody a liar, and that's a direct threat. It's witness intimidation. But there's rules of conduct. Specifically, attorneys aren't really supposed to sit there and disparage each other. So there's an extra reason that this shouldn't be permissible, but it's okay when they do it. So calling the Honorable Brian Steele a liar and accusing the Honorable Jonathan Melnick of working for defendants rather than his client, Kenneth Copeland, the state now turns its attention to counsel for Diamante Kendrick. Oh, we have a typo in his name. But to paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them, and they think it's hell. In a 1.5-page motion, the state cites to Rule 3.6 of the Georgia Rules of Professional Conduct and cherry-picks certain comments to the rule to support its motion to instruct the defense to refrain from making extrajudicial statements about this case moving forward. No case law is cited. No finely tuned order is proposed. Again, they're just saying restrict out-of-court statements moving forward, all of them. As the state accurately quotes, Rule 3.6 bars lawyers from making extrajudicial statements that a lawyer knows or reasonably should know have a substantial likelihood of materially prejudicing an adjudicated proceeding in the matter. What's the problem? The state provides no specific quotes of Kendrick's counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by Kendrick's counsel that might arguably violate 3.6. The court should decline this invitation. Remarkably, the state does not make a single argument that any statement by Kendrick's counsel meets any of the elements of Rule 3.6. Instead, the state simply offers up a single conclusory statement. So, if you guys want to check out that full motion, there were like 2 more pages of it. And that link is here. And we'll look at some of the zingers. We'll go back and revisit Steele and Adams on the same issue. Sabata, good to see you, says YSL Page tapping her pen like an FMAF reading these motions. She's gonna whip that hair. Yep, I can picture the deep breath into the microphone. Here Comes Drama says probation will always be a trap. Yep. Plea deals, probation, trappity trap. One that it seems like the district attorney especially likes to... Oh, we're going to get a quote on this that it didn't really stand out to me. I don't remember it standing out to me as much reading it last year when it was filed. But yesterday, with all of this developing and what we know now, there is a part... I'm going to come back to this point here. Probation being a trap, plea deals being a trap. The way that Fulton County specifically seems to leverage them, and the factual acknowledgments. let's go over to Brian Steele and Keith Adams. We've got this quote right here from this filing. So they include this statement. They're calling out the same thing Doug did. They want to restrict extrajudicial statements, but look at the statements they're making out of court. And one of the examples they give, I think they give like 5 or 6 of Fani Willis. It's so interesting you talk about snitching because everybody hard, right? Till they sitting in that seat. I've already said, a very, very long time. I personally have tried, as in tried a case through trial, over 100 homicides, prosecuted hundreds of them because of pleas and other resolutions for cases. So to me, I read this as her bragging. I've tried all these cases. Well, let me give the context. It's not like I tried them to a jury verdict. I haven't tried 100 homicides where the trial went to the end and got to the jury and won convictions through jury guilty verdicts. I have to correct what I'm saying here because a lot of them, their dispositions came from plea deals and different resolutions for the case. So over 100, but they weren't all tried. So really what she's doing is she's bragging about the way she uses alternative dispositions besides getting through a trial to a verdict. Pleas and other resolutions. And she says, literally all I did for a very, very long time. So, especially knowing what I know now, I think back in July, of course I had a general feeling on plea deals and probation and how that can set somebody up, or somebody who might be innocent feels like they should take a plea because they don't want to risk putting their life in the hands of a jury. And I had general opinions, but after July, we started to hear more about things like Quindary Zachary, what they wanted to do when he was being a difficult witness. Mounk Tounk came after this point in time. That's a huge one. Factual acknowledgments in a plea agreement. Love reading the factual basis from an Alford plea alive in front of the jury. like just holy moly, having to be admonished in front of the jury because she did that. And seeing all the ways specifically the Fulton County District Attorney's Office leverages these pleas. Kenneth Copeland, Woody, when Max Sharp got up there and he was like, you had this prior issue you were facing because you accused a corrections officer of, I think it was like macing him or something like that, right? You were facing like a false reporting charge. I forget the specifics, but Max Sharp brought this up when Kenneth Copeland was on the stand. And he was like, yeah. And he was like, well, did you know it was null prost? And Kenneth Copeland didn't know until Sharp showed him that paper that day that the district attorney had strategically decided to null prost something. So, let somebody think that something's hovering over their head to make their sentence longer or make them do more time or risk going back in. Don't really clarify that you made the decision not to actually prosecute. If I can find it real quick, Adam Abate, he was named in an appeal where the court found that the prosecution should have turned over information of a deal, of an agreement that they entered with a key witness in the case, where they told, it was the girlfriend of the accused. They spoke with her without an attorney. She wasn't facing charges in that matter, but they spoke with her and she could be up for charges. She had a pending shoplifting charge. And Adam Abate met with her and promised her, we'll take care of that for you. And then they don't tell the defense that they make this deal with her for a separate matter. And sometime like a month after the resolution of that case, when the person on trial was convicted, they dropped that case. So the appeals court made a finding, and the state tried to appeal their finding, and the Supreme Court of Georgia was like, no, we agree with the appeals court overturning that and granting a retrial. We agree that Adam Abate, this was a violation. So again, it's this idea that in that case, it wasn't like a probation or a plea deal. It was a promise not to prosecute. So all these different types of ways that a prosecutor can leverage the way they want to leverage to funnel and extract information to push towards a guilty verdict in my opinion, the high profile cases that they seem to want to target. They've got all these means to do it. So Oh, just a hot mess. Yeah, Kiana says we know Abate is a snake. And that's the thing, like, he signed off on this motion to... I wonder if there is a hearing for this probation revocation, if Whitaker doesn't just dismiss it for being deficient, if she holds a hearing for it. My guess is that it will be Abate arguing for it, even though Fani wrote the motion. I don't know, because they made him argue Mounk Tounk's revocation hearing. Brittany Gibbs says it's written all over his face and in that voice. Are we talking about Abate? Abate's voice. Oh, goodness. And then let's see, we can look at more from... Let me pull up the filing. Again, this was a longer filing from Steele, so we're definitely not going to read through this whole filing. This was their big filing. Because they addressed like a million things at one time. But I'll link to it in case you guys want to revisit it. Sometimes it's more fun to look at things like a second time around and go back after you learn other stuff. All right, so there's that in the chat, but we'll look at this first part is all... You see how there's like 3 different things that are addressed here? The first section of this filing is all about this July 23rd motion to restrict the defense attorneys from speaking out of court. So we're going to look at some of the highlights here. Also, big shout out here. Shamina Wright, good to see you, says, I've missed you, Kat, in chat. Glad you are here. You know, crazy circumstances, but not really surprising. So comes now Jeffrey Williams. They're going to say they're arguing all these 3 different things. We're just going to look at the response to the state's motion to restrict extrajudicial statements. And this is where we first saw the lower case. So down here we've got this... Oh, I'm not on the right screen. We've got this footnote here, and this is where we see the lowercase lawyer Love and lowercase lawyer Hilton. And that was a moment. That was a whole moment in this trial. On or about July 23rd, 2024, the state filed a motion to restrict... You see, notice that they don't put the timestamp here. In that new response today, in response to yesterday's motion to revoke the probation, what was it, 7:32 p.m.? Steele and Adams are like, yesterday at 7:32 p.m., the state filed something. And I think that stands out to me so much because think about how late the state is on homework, how late the state is on turning over discovery, how the state never filed the things they're supposed to file on time, except in what seems to me to be the pattern, when they feel personally offended by something. Love never wanted to do her homework, but if her feelings were hurt, if she wanted to ask the judge to stop granting and sustaining so many objections from the state, she's firing off a late night motion in limine. Like, that she was motivated in those circumstances where feelings were hurt. And I really think that's why Brian Steele and Keith Adams pointed out that they filed their motion yesterday at 7:32 or whatever p.m. Here they don't point out the timestamp. But the state filed a motion to restrict extrajudicial statements. We've got a footnote here that says Mr. Williams adopts in full Mr. Kendrick's opposition that we just looked at a little bit to that motion. And Mr. Williams' counsel's statements referenced in the state's motion do not violate the plain language or spirit of any ethical rule. In contrast, the state failed to alert this honorable court that before and during jury selection, when potential jurors were not fully charged, to avoid all media reports concerning this indictment, the following occurred. And now this is important because what Steele's going to lay out is all of these things as the case is getting underway. And the jury is not instructed to not be looking. The court assumes that jurors do their duty, and unless there's a specific reason to believe that a juror has engaged in misconduct, that the jury is following the court's instructions, you know, as best as humanly possible, right? Pragmatics come into play, but whatever. So this is a great point from Adams and Steele that look at all the yapping the district attorney's office was doing when the jurors were allowed to watch information about this case. And yet they're making an argument without making a specific reference to a specific statement that violated anything. They're making an argument that the jury is going to be disturbed and impacted by something when you instructed them, court, that they're not supposed to be looking. They're instructed every day. But they yapped when there was no restriction in place. So they give all these examples. A Fox 5 press conference with Fulton County District Attorney Willis, dated for May 10th, 2022. And they give the timestamp, so you don't have to go watch 2 hours and find it yourself. We're going to guide you if you want to watch it for yourself. Here's the link. And here's the quote that we specifically want to point out to you. In reference to District Attorney Willis claiming her priorities to prosecute gangs. And there's a reason for that. They are committing, conservatively, 75 to 80% of all the violent crime we're seeing in our community. And so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, and certainly if those crimes are in furtherance of a street gang, then you are going to become a target and a focus of this district attorney's office, and we will prosecute you to the fullest extent of the law. We are proud to bring forth this indictment, and hopefully to bring justice to a lot of the community who were victimized through the course you'll see in this indictment. But more importantly, the most important thing we are here to do is to keep this community safe, and we believe removing these 28 defendants will keep Fulton County safer. Now, if you ask me, this seems like something that I can picture a person, an individual like Juror 409, sitting there watching this and nodding along with. Already agreeing with this, every word, before they're impaneled on that jury. I can see it. It seems consistent. I heard from Crystal this morning, that guy, Nick. So Crystal, she had bad weather. So Crystal's doing okay, you guys. Good. Thanks for asking. And though I haven't seen her in the stream, she heard from her this morning. So good news there. That was scary weather. Gamba Kufu, good to see you, says, can they modify probation if state is harassing? I think they might try to. If it goes to a hearing, I think we'll see a request for that. I think we'll see. I saw a lot of attorneys were like, I would. But I think right now what they're going for in their initial responses, this doesn't even deserve a hearing. So, but if we get there, maybe we'll see that. Good to see you. Also, Diogo says, hello, Kat. Nice to see you. And well, hi to everyone. So big hello here to Diogo. We've got the whole gang back together. The whole gang. And Angie Leah. The whole gang. The whole gang. It is definitely a reunion here. We missed you too, Angie. I don't know if you caught the craziness yesterday. That was a time. Hey to Levon here. So we've got other examples, right? So not only do we have at least one example specifically quoted and referenced, and not just, oh, there's a bunch of videos and they're talking. Oh no, somebody's speaking out loud. We get some specific things where there's an implication and impugning of guilt in a public statement, in a press statement. Reporter, these are some serious, significant charges. I would imagine you're going to seek some pretty serious sentencing here. I know it's early, but can you talk a little bit about the sentences they might be facing? And this is before like the December 22nd through 26th plea deal bonanza, where all these individuals that were denied bond suddenly get out the same day because they agreed to take a plea. So I always love looking at stuff like this in retrospect. So Willis responds to this reporter's question. We'll ask on the different charges for the maximum penalty. And there's obviously many people that are looking at life under this indictment. You're absolutely right. These are serious times. They're serious allegations. And it is my opinion that violence in our community deserves maximum penalties. Another example. The reporter says, how big is this gang? Is that a good portion of the gang here operating in Atlanta? And how long were you investigating them? District Attorney Willis, if you look at the indictment, the crimes that are alleged within it go all the way back from 2012 to 2022. I wouldn't say that it contains, this is before they started adding like the stuff from late 2022 and early 2023. I wouldn't say that it contains every active crime that YSL committed. It is a significant gang that operates here in Atlanta, Georgia. Not every member became a defendant within this indictment, but certainly a significant amount did, and certainly some of the leadership, which is what's most important. And then D, District Attorney Willis notes that this investigation/indictment has been a long effort of the District Attorney's Office and reports on her conversation with Mr. Thomas's mother, so that's Donovan Thomas's mom, a deceased in this case, citing her hopes to obtain her justice. I also love this because we get a reference to Christina Lee and reporter George Cheedy. Reporter George Cheedy is the one who said, hey, look, when they were taking Kenneth Copeland away in cuffs off the stand because he wanted to evoke the fifth, he didn't want to testify, we were instructed not to record and report on him being taken out in the hallway in handcuffs and into custody. We were told not to report on that. So that reporting came from the Honorable Reporter George Cheedy. We get a reference here to a podcast, the podcast King Slime, the prosecution of Young Thug and YSL, released in August of 2023 during voir dire and prior to jury selection. This podcast has since stopped recording episodes, but was hosted by music journalist Christina Lee and Honorable Reporter George Cheedy. District Attorney Willis made it clear that she cannot provide specifics of the case, however, shares the following. And we're going to get these quotes again. Steele and Adams are giving the specific timestamps if you want to listen yourself, but they're also providing the specific quotes that they're raising issue with. And not really raising issue with, they're more saying, you know, why are they even making this request to restrict us without a specific reason? But look at this. District Attorney Willis, I remember when we first took office, we're screaming from the top of the hills that there's a gang problem. And people were really actually kind of treating us like we were crazy, right? There's a gang problem in LA, there's a problem in Chicago, but they did not want to admit there was a gang problem right here in Atlanta. But we kept talking about facts I knew to be true because I knew crime waves. I knew that one important person got killed, and we got a gang war for several years. So this sounds like a reference to Donovan Thomas. Reporter Cheedy brings up the 75-80% statistic that District Attorney Willis claimed in her initial press conference referenced above. District Attorney Willis, I think the stats that we're depending on are actually low. What we're talking about when we tell those numbers are self-identifying people that have already gone into the penal system, and they're identifying actually as gangs, or we're finding their mail or their phone. So we're not hitting a lot of people. The one thing that is unique about this group is it really doesn't count if you're in a gang if you don't claim it, right? So you'll find that even in police interviews, where they'll tell you what set they're from, they're proud to declare it, or they have a tattoo on it that says it, or through emojis, or through direct language on social media. So we're just talking about those that we know. This is a bit of a mouthful here, but I mean, this is a pretty big thing. You've got this statistic where you're saying, how did she initially address it with the other reporter? What was her quote? Yeah, so the gangs are committing conservatively 75 to 80% of all the violent crime we're seeing in our community. And she also said, since back in 2012, we've been looking at this to determine this. But then she comes out here, as soon as I got here, I was screaming that there's a gang problem, already concluded it. And then we get all the mentions of emojis, declarations, the police interviews, the phone calls. District Attorney Willis says, I hope that you know, for gang members, I'm hated and feared because I'm not going to apologize for bringing gang warrants or educating the police on how to bring gang warrants. And for prosecuting people that decide to get into that life. So, this is another important quote. Because we've seen the transition, the jumping back and forth. You work for APD, and then you work for the district attorney's office, and then you're back and forth. It's like a pipeline back and forth, and again, both are arms of the state as far as things like Brady are concerned. But here, District Attorney Willis, to me, this is a brag. I hope you know, for gang members, I'm hated and feared because I'm not going to apologize for bringing warrants or educating the police on how to bring gang warrants. So we're making sure this is a tough tether here that can't just be easily separated. District Attorney Willis, it's so interesting you talk about snitching. This is what we read earlier. But this is just some crap too. They're sitting in that seat, and then she brags. I personally have tried, over 100 homicides, but prosecuted hundreds of them because of pleas and other resolutions for cases. Literally all I did for a very long time. When people get to sitting in that seat, more often than not, they're snitching because the choice is life, or you can tell what someone else did and what their involvement was. And so that's really cool to say on social media, But when it's you sitting in there and your mama and your woman, you got a baby on the way, you got all these other responsibilities as a man you need to tend to, you got to make grown folk decisions for you and your family. And so often the decision is I'm going to tell the truth and wrap this up for me. So there's so much here. So if you speak to get out, she's asserting that it's the truth that you're speaking to get out. It's also very loaded. There's gender bias here that just seems crazy. Like, you've got to be a man and tell the truth to get out. But if you ask like the general opinion of the chat, I'm sure a good portion of people in the chat would say, when someone's labeled a snitch, they're probably going to be emasculated and called the B word, which is it's not really, I wouldn't say that that's being a man. But this is what Fani Willis says. This is what Fani Willis knows. And again, she's also saying they're snitching because the choice is life or speaking. So earlier when we heard her say she wants to go for the maximum, why is she seeking the maximum? Why is she seeking the maximum and then also bragging about trying but actually getting pleas and other dispositions for over 100 homicide cases? You go for the maximum and you hope it's so scary that someone just takes a plea because they don't even want to take that chance. That's really what's being said here, if you ask me. Lawyer love, and this is capitalized because it's the beginning of a sentence. Steele's not that petty to force a lowercase here. Lawyer love's motion to restrict extrajudicial statements must be rejected. And again, if you're joining now, we are looking back at a prior motion that I thought was a great throwback in relation to the request to punish Jeffrey Williams for making a social media post. It is rich, audacious, and hypocritical that the state seeks to critique as unethical the single statement by Mr. Williams' counsel, which contains accurate factual assertions. As an overarching principle, the Rule of Professional Responsibility 3.6, Comment 1, makes clear that just like the framers of the United States Constitution envisioned almost 250 years ago, when they mandated that those accused of crimes are guaranteed the rights to a public and speedy trial. He pulls this quote, "There are vital social interests served by the free dissemination of information about events having legal consequences and about legal proceedings themselves." I mean, look how much we want to see what's going on. Even to the point where we are interested in seeing the hearings, right? Not just the juicy trial. We want to see the hearings. We want to see the quote-unquote boring proceedings. And in my opinion, the public has the right to do that. They want to do ex parte hearings in hidden chambers. The public has a right to know about the threats to its safety and measures aimed at assuring its security. So how is this effort to make the community safer? How are you actually doing this? Are you accomplishing it? Are you doing what you say? It also has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. Furthermore, the subject matter of legal proceedings is often of direct significance in debate and deliberation over questions of public policy. So ever since the inception of this RICO indictment, even before, we get to jury selection, there was already a huge conversation around the use of Georgia's RICO statute. And I think already early on, the use of lyrics in social media posts were being highly contested. So, yeah, not only could it be something of significance to the public and in debates or public policy, but I think you'd be stupid to claim there wasn't a demonstrable public interest. Oh, okay. Hold on. This one's a Steele doc. And this one is Kendrick. And I don't think I don't have a link to the filing handy. I just posted, it was a 2-page, I tweeted it yesterday, the state's initial motion for the extrajudicial, to restrict extrajudicial statements. It was 2 pages, so I just put the screenshots on Twitter yesterday. Oh, well, anyway, there's the docs, you guys. But yeah, we want the docs, we want access to the filings. Unless there's a reason for something to be restricted for, you know, a genuine security issue, confidentiality issue. I get it. I'm not like that crazy that absolutely everything, there's never an exception. But it's absolutely wrong for the state to think that anything they don't want the public to see, there's a grave need, a grave danger if the public finds out anything that we think could look bad for us. Like, that's just stupid. Ugh. Let's see, what did they go on to say here? Did it scroll into a different place? Okay, I think it was here, because it's the starting with lawyer love. So down here, rule of professional responsibility 3.6, comment 1. That's what we just looked at. Moreover, comments 5A and 5B delineate certain subjects about which a lawyer could speak, which are more likely to have a material prejudicial effect on a proceeding, and those subject areas are more likely than not to have no material prejudicial effect on a proceeding. In a criminal case, comments which are more likely to have a material prejudicial effect on a proceeding include subjects relating to the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation or witness, suspect in a criminal investigation, or a witness, or the identity of a witness, or the expected testimony of a party or witness. And so, for example here, a good example of this would be, you know, sometimes, obviously not everything that is discovered or investigated or said in a statement or an interview makes it into trial. So if an attorney is talking about something that an attorney on either side is talking to the press about something that, you know, a juror could be listening to and hear during the initial press coverage of a case, and they're aware of that and they could potentially be on the jury pool, but then that thing isn't material, it's not admissible at trial for whatever reason, but it's already out there and a juror was already exposed to it. They might not realize it was material. They might not have gotten stricken during voir dire. That's why they're setting some standard that, yeah, there are certain things that just because it's come into somebody's knowledge, we don't really want attorneys putting all of that out there and speaking on it and opining on it to the public. 2, the possibility of a plea of guilty to the offenses or the existence or contents of any confession, admission, or statement given by a defendant or suspect that a person's refusal or failure to make a statement. What is more relevant to the issue at hand is the commentary relating to those subject areas, more likely than not, to have no material prejudicial effect on a proceeding. The subject areas include information contained in a public record and the scheduling or result of any step in litigation. So again, this is all July. This was the conversation surrounding this ex parte just happened. This ex parte meeting with Kenneth Copeland just happened. They were moving to recuse Judge Glanville. Judge Glanville, they're going to recuse him, but they want to keep the case going and substitute a judge, swap the judge out in the middle of a very long trial, right? So this is, a lot of the commentary was like, how can the jury reconcile, how can this be a fair trial if we're swapping judges in the middle of it? How do we overcome that? And that's commentary on a step in the litigation. So, every factual allegation in the statement made by Mr. Williams' counsel is contained in the public record. And I love how they argue this. Specifically, Mr. Williams has repeatedly, in public filings, as well as by and through his counsel in open court, maintained his innocence. Mr. Williams filed motions for speedy trial. The recused judge, Lawyer Love and Lawyer Hilton, have been accused of and found to have run afoul of their duties under the law. And Judge Glanville has been recused and disqualified from his role as trial judge based on a motion brought by Mr. Williams. As this honorable court is aware, Mr. Williams' trial is televised live from gavel to gavel. And this is like my favorite stupid little thing ever. The coverage is available to the public at the click of a link, even when not watched live, as recordings are maintained on youtube.com. And I love this because it's just like, it's so available, and especially at this moment in time, that month of July, especially if you've clicked one thing about this case ever before, if you were to click YouTube and just go to youtube.com, not only can you easily search for and find something about this trial, but chances are it's going to headline on your For You page, your homepage, because that's how prominent and accessible and public this trial was. So for them to just say all you have to do is go to youtube.com. You don't need to mince through the woods, climb through the bushes to find it. Is hilarious to me. It's a very good way to argue how widely available something is. Thus, the likelihood that Mr. Williams' counsel's repetition of information in the public and or findings of the court could materially prejudice an adjudicated proceeding in the matter is absurd. Moreover, the jurors in the case have been provided cautionary instructions and admonitions countless times, at least daily over the 100 days of trial, not to listen to anything related to this case. So unlike pretrial comments, which the state is guilty of making, there is no basis for Mr. Williams' counsel to believe that his statement will have a substantial likelihood of materially prejudicing an adjudicative proceeding. So, there we go. This goes into, conversations, arguments relating to requests for mistrial and substitution of the judge. Again, if you guys want to read that, that's linked in the chat. But I really thought that was an interesting thing to go back and see. Because to me, this motion to revoke Jeffrey Williams' probation, it's in part, get Jeffrey Williams by any means necessary. We've got like 15 years to do it, maybe 10 years to do it. But alternatively, it also seems like, stop talking about us. That's really what the argument seems like. Stop talking about us, Jeffrey Williams, and anybody that is on social media to see something that Jeffrey Williams might say. Like, just a mess. Yeah, Here Comes Drama says, yeah, we're not Viverito in the bushes. We're not hiding this. We don't need to comb through the bushes here to find the information. We could just go to youtube.com. Cowboy says, yes, speedy trial 2 years later. Let's just take 10 months for jury selection. Oh, Cash Money Cass with the 403. Love it. What I thought was fun, if you guys paid attention to the ASAP Rocky trial, Rule 403 isn't just a Georgia thing. It's adopted from the federal rules of evidence, which uses 403 for the same, waste of time, confusing to the jury, all those different bases. But California, uses their own state moniker. It's like 300 something. So, Lewin, the prosecutor in the ASAP Rocky trial, his objection, he just kept yelling, I don't know if it was 352 or something like that, 356. But in that trial, the number was 350 whatever, and Lewin just kept crying every time Joe Tacopina is making some argument. Your Honor, 356, 356. Or again, whatever, I don't know the exact number. That was the time. Oh boy. Just the whole time. But yeah, let's check and see if we got any. I would love to see no hearing at all. Paige is just like, nope. But at the same time, I think it will be some fiery arguments and some great lawyering if there's a hearing on this revocation for Jeffrey Williams' probation. Yeah, I don't think I see any updates from Joseph Papp or Thugger Daily, the Honorable Thugger Daily. Although Thugger Daily did highlight this, what could be perceived as a threat by Brian Steele and Keith Adams. If a hearing is needed, Mr. Williams will be prepared. Oh. Shannon Alexander, good to see you. Thank you for the super. Says, good afternoon, KNW and chat. Missed you all. Another family reunion on DA Bullarchy. Yeah, that's a good way to put it. That is why we're here today. We're gathered here today for more BS from the DA. Great to see you all. Right back at you, Shannon. Thanks so much for stopping in. 403 is ready. Says, hello, Kat and KNW gang. We better be aware. And we gotta be prepared. Let's see. Katie Sleva says, Operation Planter still makes me laugh. Now, do you mean the PowerPoint presentation in and of itself makes you laugh? Or are you additionally or separately noting that Viverito this week pretending she doesn't know anything about Operation Planters? Do you think that's funny? Because I think both are hilarious. I think it's also very funny. Remember, Judge Glanville wanted to exclude this Operation Planters PowerPoint just because Love wasn't doing her job and turning things over to the defense. This is where we have that April 17th screaming match where Love is screaming at Glanville and he just brings the jury back in. Later, when Whitaker is presiding over the case and Dennis is about to come back on the stand, state wants to get this PowerPoint back in, and I think Shart and Steele and maybe Carrington Matthews all jumped up and they're like, that was excluded previously. That was a ruling by the previous judge. And state fought, and Whitaker's like, well, let's just go through it and see if there's stuff relevant in it that you need to bring in. So the state is going through it. This is one of the funniest hearings. Slide by slide. They keep pulling up a slide, and like 9 for 10, it felt like. Every 9 slides out of 10, it would be a nope, 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 that's repetitive, that's irrelevant, that's prejudicial, nope, it's not coming in. And every once in a while, like, okay, that random picture can come in. So even though Whitaker gave the state an opportunity for her to reconsider her ruling on this PowerPoint, they ended up giving up on the PowerPoint by the end anyway. So, just a hot mess. Oh my goodness. Yeah, Happily Angry Lawyer says prepared defense lawyers are a threat to their BS. Oh no! Just crazy. Teo A says Thugger Daily should be subpoenaed. He's technically in the exhibits now. His like profile is in a screen capture. So he's technically part of the record. Not as a witness. He is officially on the record with Mel. I'm not a lawyer, but Shannon Alexander says the DA off needs to spend more time preparing my dad's murder case. Yes, you've talked about that previously. So the office has been lingering on that, and we haven't been here for a while, and you were talking about this last fall already. So it already been a long wait when I remember you talking about it last year. And now we're in April of 2025, and we still don't have movement there. We still don't have movement there. So, you're saying that imagine sitting next to the defendant who committed this act after violating the bond order, he still walks the street. Yeah, and then we get these statements in relation to YSL where we're going to go for the maximum, we're going to solve this problem, we're going to get them off the streets. Homicides, I've tried 100 homicides. And then we have this problem. There was a separate statistic, and I don't remember the exact statistic, but Fani Willis in some press conference in like 2022, maybe 2021, said that there was an overwhelming amount of homicides that were sitting uncharged, unindicted. So shouldn't that be the goal? Why is the focus on people that you've got in custody already? The difference is it looks like you want to get this RICO thing moving and put this RICO on your record and not actually do the thing to protect the community. So I'm sorry that you're going through this. And it's like, generally, it's like shocking to hear that, months have gone by that I'm aware of. So, and this is still an issue. And it sucks, but when I think about it being Fulton County, it's not surprising to me to hear that they specifically are still not making any motion on it. Like, just crazy. So that's really crappy. And if you ever want us to, like, push buttons and, like, raise a flag on this issue, let us know. We can talk about it if you want us to look at the case at all. Or, I guess it's not really. If he's still walking out, it's just sitting as a case in purgatory. There's no motion for us to look at, but we can go back. We can go back and rewind. And I was looking, I'm sure Happily Angry Lawyer is not surprised to hear about another case just sitting in stasis. Just crazy. Yeah, Here Comes Drama says you gotta love a good 1990s PowerPoint presentation. I forget, a witness in the Karen Reed trial wants to bring in like 100-slide PowerPoint. Something like that. 100-pager. Like, just holy moly. Just crazy. Yeah, Darren Mills is an example here. Darren Mills sitting for 3 years. And I think we were talking about handwritten, we started talking about Sarah Boone, and I qualified her and said I don't really have much sympathy there for her handwritten notes. But because we were talking about our handwritten notes, brought up the point that it's, when you see someone writing these handwritten notes, it is an indicator that this person's sitting behind bars in a place where they're already restricted from accessing the means of which to do research and fight for their own defense or any other necessary legal arguments, when you see them writing handwritten notes, you know, they don't have an attorney fighting for them. They don't have a team, and they might not have the knowledge of the law or the legal avenues they can use to seek some type of post-conviction relief. Is just crazy. And Darren Mills is the perfect example of that. I haven't seen you post on that recently, but I assume you're going to do a video on that maybe in the future. Let us know. Let us know. Okay, and then let's see. Okay, and the channel says the bond revocation hearing last long month. Cat Fink, good to see you. You were missed yesterday, so were you here and just not able to type? Good to see you. Hope you're doing well. Dear Revoke Christian, good to see you as well. You knew that the adults would step into this fray. Listen, you know, there's nothing I would not fight the opportunity to watch. And I guess this would only really relate to Keith Adams and Brian Steele, but I don't know, it would just be kind of, I can picture, you know, like a Doug Weinstein appearance sitting in the gallery if we have a hearing on this issue. So even though it's really Steele and Adams, they're the ones that would be arguing this, I can picture some of the others showing up. So super, super love that. Good to see you, DWC. I'm sure you've been covering a bunch of stuff still on Fulton County shenanigans, way more than me. I look at some of it over on YouTube when like you talk about it, or on X. I'm mostly on X for those updates. The subpoena hearings, Fani having to pay up like $50K back to the merchant law firm because of all the public records requests and her failure to respond. Following a little bit of that. And, you know, from a top level view, it's just that hypocrisy. You know, you don't need to show up for you're subpoenaed to show up, and you don't show up. But you can run and write this filing at 7:32 p.m. last night. You can go and sit down and speak to the news about it. It's just a lot. It's just a lot. With that being said, dear Woke Christian, whenever I type your name to pull you up, I always start typing DWC like an idiot, as if YouTube's gonna get what I'm looking for. All right, there we go. You guys check out DWC. Tons of coverage here on, and I'm just going to call it Fulton County shenanigans because, you know, if I start listing the specifics, it'll be a long list. So big shout out here to DWC. Good to see you. Always love seeing your green. It always makes me think you're part of the gang. Happily Angry Lawyer thinks Whitaker is going to have a hearing just to yell at the state. I want that. I secretly want that. I don't wish that on somebody that's inconvenienced and has to deal with this type of matter, right? So of course I ultimately would prefer the resolution just dismissing this. Don't let them bring it back. But at the same time, selfishly, would love to see this go down. Yeah, Cat Fink says, where are the tacos? Taco Thursday? Taco Thursday. BigBabyJane, good to see you in the chat as well. That guy Nick, has Thug actually released any music yet? I think only snippets. I think he's got like teasers and snippets, and he's been teasing his upcoming drop, but and I don't know, but everyone's saying that it's a pattern for him to tease a drop for a long time and then not actually drop right away. That's his marketing strategy. So imagine if he gets in and just says that this is marketing for his new album. Because I think he's been using Oi Scooty, which is supposed to be like the biggest star in the universe that we know about. And what if he's like the biggest liar in the DA office promoting my drop of the biggest star in the universe themed album? So who knows? Technically, it could all just be marketing. Here, Shannon, I'm going to give you my email. That way you don't have to put your number in the chat, because you never know. I mean, I love the chat collectively, but at the same time, you never know who's hanging out in here. So there's my email in the chat if you want to send your number. I'll reach out to you. But Team Mrs. Fani's just in her feelings. I'm telling you, that's why they put that 732 mention, because that's just been a consistent pattern from the state. They don't respond. They're slow on doing their homework. Even when they're reminded that they had something due, they're still dragging their feet. But let their feelings be hurt. They're running to the keyboard like that cat meme that's like this. Oh, goodness. I also want to give a big thank you to Beth in Seattle. Thank you here for the love on Cash App, as well as M. Edwards. Thank you so much, you guys, for showing the love. I don't check that. I always feel bad. It's really nice that you guys support it all. You don't have to, and I don't mean to miss anybody, and I feel really bad when I miss you guys. So sorry to Beth and M. Edwards for only seeing that today when you sent it yesterday. Big appreciation to you guys, though. Hey, Ayana, we are wrapping it up. I feel like let's do this every time we start to wrap up a chat. We'll just find someone that's coming in. Today it'll be Ayana Davis. We'll find someone that's coming in and say, hey, and we'll be like, all right, hello, hi, bye. Where do you guys want to go over to? Are you guys doing any following Karen Reed today? Do you guys want me to look for something Karen Reed related? I've missed everything Karen Reed today. I don't know anything that's going on, so. And what was the name of the channel you guys recommended yesterday? It was alliterative. Her name, it was something with a T. Touche recommended her. Maybe I can find it in my history real quick. If she's live, we can go send that over, because Touche recommended her coverage of Karen Reed yesterday. And a bunch of other people in the chat also had positive things, like, oh, we love her, she's great. Tanika 2 cents. Let's see if she's live. Okay, I don't see her live, so I'll link to her stream here, or her channel. Tanika 2 cents is her name. She was highly recommended yesterday. And I'm glad her name was actually alliterative. I remembered it was like 2 T sounds. And then let's see. Closing arguments in Monica Cementilli trial. We could do that. Let's see if I can pull one up. YouTube. And Sylvia's doing, you know what, before I assume I'm sure she'll talk about this, or the happenings with the revocation. Is she talking, let me see if she lists what other topics, if she's going to talk about other topics as well, before I just make an assumption. Is it on her main channel? Sylvia. Okay, so I can't redirect to her. It's not letting me redirect there. It won't let me choose it. So I don't think she has that enabled. But it looks like Infamous Sylvia is going to be going live. And that looks like her Infamous. Yeah, it's Infamous Sylvia. So that's her main channel. So she'll be going live. Nick is live. What is Nick doing? And I can select Nick, so yeah, I can redirect to Nick. I have permission to do so. Oh, okay, yeah, this is the Judge Boyd trial. I didn't know the TK trial was Judge Boyd. So it's the TK trial and a Judge Boyd trial all in one. So we'll go over there. People have spoken very highly of Judge Boyd's court. And I know separately there's been interest in the TK murder trial. So 2 things in one right there. Okay, and Teo says, yeah, she's going to be talking about the RICO. So I would say, if you want to check that out, Infamous Sylvia is going to be talking about, you know, YSL, the updates happening there, it looks like. We'll redirect over there. Factual Lie has also just shared a link. Flesh of the Gods is going to be live tonight. talking about, you know, the usual shenanigans with YSL, I'm sure, but maybe also getting into any updates in the Yellow Beezy, maybe YNW Melly. Yeah, there's a whole bunch of people that I'm sure are going to be talking about this revocation. With that, we'll wrap it up, you guys. We'll get some walk-off music going. Pick a random... Should I pick a random song from StreamYard? Let's do... Want to do Night Driving or Lo-Fi as walk-off music? Oh, wait! Hold on, we could do ABCs of Steel! Alright, you guys, we're going to wrap it up. We're going to do ABCs of Steel. I love that, because we have Steel back in with this motion, this filing today. So that's going to be great. That's the perfect way to wrap up. See you over in the YouTube chats elsewhere, wherever you guys go. I'm going to hop around. Thanks for hanging out today. And let's see. Shannon, I will look for an email from you. And let's run this back one time. Take care, everybody.
A as in Alicia, and B, Your Honor, as in Barry. C as in Colette.
G as in Goldfeather. K as in Kittens. M as in Magic. P as in Perfect. C as in Colette. U as in Unbelievable. V as in Victory. W as in Wonderful.
O for objection. S for sustain. P for buffering. E for Pepto-Bane. S for slime, my friend, and you as in what you mean. I as in adultery call. M as in may I sleep. All the ABCs of steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. G for gavel slams down E. T for telling anything. R for rights we stand. I for infinity. Life's a courtroom dance. Keep your stances strong. With ABCs of steel, you can never go wrong. Oh, the ABCs of steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Of steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Oh, the ABCs of steel makes me feel so real.